welcome everyone. We are so excited to see all of you for Constitution Day. Yay! Woo-hoo! So I thought I'd read the last paragraph that I just read in one of these, sort of tributes to Constitution Day. So the next time September 17th rolls around, eat a hot dog, watch some fireworks, and celebrate Constitution Day. I think we forgot the hot dogs, but we have some cookies, no fireworks, just in case you were worried we were going to do that here. That fateful day in 1787 when 39 sweaty men dressed in stockings signed their names to the U.S. Constitution. Remember how they argued, hoped, feared, persevered, and most important, compromised to create a lasting document that still governs today. July 4th may be remembered as the day the United States was born, but September 17th marks the country's passage into adulthood, laying the groundwork for 2 centuries of remarkable expansion and spectacular achievements. So I thought that was a fitting way for us to think about what the project is for us today in thinking about the 14th Amendment. And so one of the great things about Constitution Day is that it gives us a chance to have 3 spectacular people from the law school talk about what the impact has been of the 14th Amendment and how in this anniversary, one more anniversary, everybody knows, 14th Amendment is how old? 150. That was for the Jeopardy money, 150, right? And so we're going to have each of them speak in just a second. But before we start, I thought, what would be more exciting than reading the first section of the 14th Amendment? Pretty much nothing. So I'm just going to go ahead and read the first section of it, just so we're reminded, again, of this link. You think of this as sort of, it's got to be really long and tedious. I promise it's not going to be long or tedious. So here it is. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So that's our subject tonight. All right, so let me introduce everybody. So we have on my right, Jasmine Gonzales Rose. She is a professor, an associate professor of law here at the law school. She is a critical proceduralist and is particularly interested in the intersections of race and language with 2 areas, juries and evidence law. She is the nation's leading expert on juror language disenfranchisement, I'm going to get it out here. It's 5 o'clock! Okay. And juror language accommodation. So please join me in welcoming Jasmine. We'll do all of them before we have everybody start. So Debbie Brake over here on my left is the Associate Dean for Research and Faculty Development. She is also the John E. Murray Faculty Scholar and Professor of Law. Her scholarship explores the theoretical underpinnings of various dimensions of equality law. She has written articles on retaliation and other negative reactions to equality claims, examining how constitutional and statutory law responds to persons who challenge inequality. So please join me in welcoming Debbie. And last but of course never least is our friend David Harris. David Harris is the Sally Ann Semenko Endowed Chair in Law. He studies, writes, and teaches about police behavior, law enforcement and race, and politicking and immigration, search and seizure law, and national security issues and the law. Professor Harris is the leading national authority on racial profiling. So please join me in welcoming David. Now, I may not be able to read read this evening, which now indicates that perhaps I should have brought my reading glasses, but we're not to that point where I'm admitting it. I just want to let you know, right, what our goal is tonight is to have everybody up here speak for a little bit about their piece of the 14th Amendment, and then we're going to open it up to questions, and we really would hope that all of you feel free to participate, join in the discussion at that point. So that's how things are going to proceed from here on out, and just in case you're worried about my moderating skills because of my inability to read, I will point this out to you. Many years ago, I was on the state championship team that won the Bicentennial of the Constitution competition. We came to DC. We did not win the national championship, but still, we represented Illinois well. So just in case you were worried, I'm here with some bona fides. So with no further ado, I'm going to turn it over to Jasmine.
All right, happy Constitution Day. So my role today, I'm going to talk about one small issue. I'm trying to evaluate how effective the 14th Amendment has been in thinking about ensuring equality in our country. It's a difficult thing to measure, to assess. How do you do it? I'm going to be looking at the Equal Protection Clause, which I don't have to read, so thank you for having done that already. And think about, I've limited the scope to that one clause, but thinking about how do you measure its success. And one way I think you can do that in thinking about equality is thinking, how is equality furthered in the context of democracy, in the context of self-governance? And 2 years after the 14th Amendment was enacted, the 15th Amendment was enacted, which deals with voting rights, that there cannot be an abridgment to or denial to the right to vote on the basis of race, color, or previous condition of servitude. So I'm not talking about voting, but what is something that is, I think, second in its importance for our democracy, our self-governance, and I think that is jury service. Jury service is incredibly important. So I want to talk about how the 14th Amendment has protected against racial discrimination in jury selection. And I'm going to do this by looking at not just an area that's established, but an area that has not been as explored, which is dealing with the exclusion of people of color who happen to have minority accents. And so equal protection is one of the most important constraints on racial discrimination in jury selection. The use of facially race-neutral statutes to exclude racial minorities has been constrained under the 14th Amendment and found to violate equal protection for quite a while. There's a couple of early examples that some of you constitutional scholars might know about, and students, such as the 1935 case of Norris versus Alabama, which there was a challenge to the key man system, where basically there had to be a recommendation by a jury commission to select names of male citizens who could serve on juries. And here this had resulted in the exclusion of all African American persons from jury service in that county. And the Supreme Court found that to violate equal protection. Similarly, in Smith versus Texas, the Supreme Court found that although African Americans constituted 20% of the county, that there had only been 3 African Americans who had served on juries, even though thousands and thousands, I think about 6,000, were eligible. So here, the idea that this wide discretion that had been permissible in courts for a long time that allowed for discrimination against racial minorities was not permissible. And there's just a part of that decision I want to read. It says, "It is part of the established tradition in use of juries as instruments of public justice that the jury be a body truly representative of the community. for racial discrimination to result in the exclusion from jury service of otherwise qualified groups not only violates our Constitution, the 14th Amendment, and the laws acted under it, but it is at war with our basic concepts of a democratic society and a representative government. Now, I want to talk about a modern way that many Latinos and Asian Americans and other people of color who are perceived to be foreign are excluded from jury service. So first, a story. I see a couple of my students here, and they know I love to tell stories. So one day in Connecticut, a gentleman who I'm going to call Ed Figueroa, he was called to jury service, and he shows up and he's asked a bunch of questions. He's asked over 100 questions over a period of over 20 minutes, and he answers them all carefully and clearly in the English language. But through that dialogue, it becomes clear that the judge is a little uncomfortable. The judge starts asking Mr. Figueroa about his English language abilities by saying, you're not a native English speaker, are you? And he says, no, I'm not. He was Puerto Rican, and he says, but finally he said, I know what you mean, Judge. I have a heavy accent. And they're just, oh, no. I ask everybody this. It's not just Spanish, none of that. And so Mr. Figueroa is excused, and on the record you can see the judge and the prosecution are talking about Mr. Figueroa. There's no denial that he can speak English perfectly well, but there starts to be a concern, do you think he'll be able to communicate effectively with the other jurors? And here we are in a jurisdiction that's 45% Latino. The vast majority are of Puerto Rican descent. So you start to wonder. They call Mr. Figueroa back in and they say, look, you just weren't selected for jury service. I don't want you to think that anything you said was wrong. Any of the questions you answered were wrong. It's just the way it worked out. Well, it's true. Nothing he said was wrong, but it was the way he said it. It was the way he pronounced it was wrong. This is a classic example of accent discrimination in jury selection. And how does the 14th Amendment deal with that? How does the 14th Amendment address that? So basically, it's well settled that he couldn't be excluded from jury service on the basis that he looks like a racial minority. But he is, and he was, because he sounded like a racial minority. So we know that that most states and in the federal courts there's English language juror requirements, and those vary in their stringency. Some have to do just with speaking and understanding, others with writing and reading in the English language. But nowhere is there a de facto requirement that one must speak with a majority accent. However, in practice, that seems to happen time and time again. And so equal protection has been applied to limit, in many instances, discrimination on the basis of race. But the understanding of what race is has been very narrowly defined. And there's so many ways that, similar to physical characteristics, race is an external, language and accent particularly is an external marker of race. And it's also often core to one's own racial identity. Now, accent isn't only used to identify people as being of a certain race, and that's true for people of all different races, but it's also been used to subordinate people. Just as there are negative traits and characteristics associated with things like skin color, phenotype, hair texture, there also can be with accent. And studies in social science and sociolinguistics, it's that 5 o'clock. 5 o'clock slur that comes along, that there are some negative associations with certain accents, particularly Hispanic accents are one of them, that can be seen as being dirty, foul, uneducated, and un-American. Now, in the courts, we've seen that accent discrimination in jury selection can happen a couple of ways. One is like the case of Mr. Figueroa, where he was struck for cause by the court. Another is that it can be used as a justification for a peremptory challenge. So after a peremptory challenge has been challenged under the Batson doctrine, the parties say, oh no, we're not discriminating on the basis of race. Really, we're concerned about that prospective juror's ability to communicate in the English language, even when there's no evidence of that. So here what we're seeing is too often jurors are being struck, prospective jurors are struck because of their accents. Now, this can violate both the juror's rights. It can also violate, in a criminal case, the criminal defendant's rights as well. Now, unfortunately, many courts, even after a Batson challenge, have been too quick to find language, and specifically where there's no demonstration of English language efficiency, accent to be considered a neutral reason for striking a prospective juror, even though often accent is not race neutral. Many times, particularly for Latinos, Asian Americans, accent is a racial characteristic that's used as a proxy for race, ethnicity, and national origin discrimination. Now, of course, there are some instances where there are English language learners who cannot serve without language accommodation, of course. But again, too often trial court judges or counsel's perceptions and claim that there is incomprehensibility. And this, I think, can really have both implications of implicit bias and overt bias. Racial characteristics can include accent. Accent itself is a racial characteristic. So here, there really is an opportunity to see how the 14th Amendment, which has been utilized for so many years, with some success and some real limitations, even in a traditional sense, how it could be recognized in the case of accent discrimination. As I started out talking about the case of Mr. Figueroa, in that case, the Connecticut Court of Appeals and the Supreme Court of the state found that there was no reasonable basis in the record to support a finding that Mr. Figueroa's English language abilities were insufficient. Still, the Connecticut Supreme Court and the Court of Appeals found that it was not a fundamental error requiring a new trial. If the judge had excluded a prospective juror because he looked like a racial minority, it would have been considered a fundamental error, likely requiring a new trial. However, excluding a prospective juror because he sounded like a racial minority was treated different. This is an injustice that's too often overlooked in our legal system. And I think this is a real example of how the 14th Amendment has great promise and some shortcomings. So I hope we can have a conversation just using this as one example.
Let's see how proficient I am at the microphone. Can you all hear me? Okay, all right. Thank you all so much for coming to Constitution Day. We're really happy to have this kind of turnout. Okay, so I'm going to focus my remarks on gender and what the 14th Amendment means for gender. Gender was a latecomer to equal protection rights. And as one scholar puts it, gender is still not part of the constitutional canon. The stepsister, not the paradigm of what the 14th Amendment is typically thought of as covering in the constitutional canon. And yet, the 14th Amendment has provided and continues to provide at least a foundation of rights related to gender. So in my remarks, I am going to sketch the beginnings of covering gender in our constitutional history, some thoughts about the limits of that coverage, and then some reflections on the legacy and promise, which I hope will at least undo a little bit of the mostly downer of a talk that I'm about to give with respect to gender in the 14th Amendment. So, inauspicious beginnings, let me just say, to put it lightly. It's putting a good face on it to say inauspicious beginnings. But women had high hopes as the 14th Amendment was being drafted and heading toward ratification. High hopes that it might do something meaningful for gender equality. After all, in 1848, 20 years before ratification, the Declaration of Sentiments at Seneca Falls made some strong claims, including that among self-evident truths were that all men and women are created equal, followed by a list of demands, most importantly at the time, suffrage. These claims were overtly rebuffed in the drafting of the 14th Amendment. In fact, in a very backlashy kind of move, the second section of the 14th Amendment, one of the least celebrated, not one that the Dean read, of course the Dean read the celebrated part of the 14th Amendment, but the second section of the 14th Amendment, it marks the first time in our constitutional history, first and only time, that a set of rights was exclusively set aside for men. Not one of our finest moments, but the second section of the 14th Amendment created a remedy for some deprivations of voting rights against male citizens, and the remedy being a reduction in state appropriation. Really a terrible way of approaching voting rights. The 15th Amendment comes at it more strongly, but it marks a deliberate, I think, effort to silence the Seneca Falls activists, silence the upstarts, and limit a set of rights to men, which made it very hard from that point on to argue that equal protection in that first section meant anything for women if it was so clear that women weren't even getting the vote. And it had some really unfortunate effects at that very moment of that drafting of the second section. Women of all colors who had worked with abolitionists and pushed for a broad grant of rights in those Reconstruction amendments were brutally rebuffed. And some white women, not all, but some white women at that moment reacted by turning against their former allies and actually opposing ratification, some with some very painfully racist arguments about the carve-out of women's equality, creating rifts that lingered painfully for decades between movements for racial justice and movements for gender justice. The fact is that the debates over ratification themselves made it very clear that it wasn't, at the time, 1868, thought to be doing anything for gender equality. One opponent of the 14th Amendment warned about what this might do for marriage and destroying marriage if married women were to have equal rights to property, at which point Thaddeus Stevens, a lead supporter of the 14th Amendment, responded, not to worry, where all of the same class are dealt with in the same way, then there is no pretense of inequality, meaning as long as you treat married women like other married women, it's fine. They're not in the same class as men. Don't be ridiculous. It will not affect coverture. So it took another half century of women's activism to get voting rights, which didn't arrive until 1920 in the 19th Amendment. Okay, turning to the courts then, what was going on in the courts? Well, the first 100 years of Supreme Court decisions on the 14th Amendment with respect to gender, very inauspicious. On myriad fronts, the court rejected women's claims to equality, including in the practice of law, service on juries, even the ability to work long hours to earn overtime pay. Now, as we get into that, past that first 100 years, I should say, and into the beginnings of an early women's movement, we started to see some Supreme Court decisions that were of deep importance to women, recognizing 14th Amendment rights in the realm of reproductive rights and women's control over their fertility. But these cases were grounded in gender-neutral rationales of privacy and liberty. For example, in Griswold in 1965, foregrounding a right to privacy to use contraception in the gender-neutral, undifferentiated marital unit. No acknowledgement that it's women who bear the bodily results of conception, or for most, the lifelong of caretaking that follows, at the time anyway. And of course, Roe, 1973, recognizing a right to terminate a pregnancy, but in the de-gendered grounds of a physician's relationship with his patient. Neither of these cases acknowledging the centrality of these issues to women's economic, political, and social equality. So, once the second wave of the women's movement was in full swing by the 1970s, we did begin to see constitutional 14th Amendment rights for gender equality gain more traction. But let me just say, these cases hardly cut to the core of gender injustices. Who can forget that the landmark case in 1976, for the first time setting down a firm constitutional standard of intermediate scrutiny for sex discrimination, involved the pressing issue of men's ability to purchase 3.2 beer. I'm not making that up. Craig versus Boren, 1976. Okay, not all of the cases were trivial that the court was taking in this era. The 1973 case, Frontiero versus Richardson, struck down a federal policy limiting for service people in the service, an automatic spousal and housing allowance to men. Women for their spouses had to prove financial need under a very high bar. And that case, frankly, still resonates as a case of equal work for unequal pay. But for the most part, most of these cases involved male plaintiffs challenging the few realms of the law that purported to benefit women. Meanwhile, enthusiasm for an equal rights amendment that would amend the Constitution to actually explicitly recognize women's right to equality, that enthusiasm gave way to anxiety. Anxiety about what it would do for women's roles in the family, and anxiety about what it would do to, yes, the bathroom, the center point of many deep-felt equality fights. By the early 1980s, it was clear that the battle for ratification had been lost, stopping with 35 states, a few shy of the 38 needed to ratify the Equal Rights Amendment. Nevertheless, the court came to embrace a version of heightened scrutiny, just shy of strict scrutiny for race, that probably had its high water mark, at least for now, in the 1996 case of United States versus Virginia, where the court struck down VMI's exclusion of women from the prestigious military academy on the grounds that some women, yes, some women, can perform as well as male cadets in that environment. Okay, now I want to talk about three limitations in the doctrine that I think do really curb what the doctrine of equal protection can do for gender equality. And one of these is that it only covers state action. Of course, the dean reading the amendment, if you were listening closely, you heard no state shall. You have to have a state actor to infringe 14th Amendment rights. And of course, some of the deepest gender injustices come from private so-called actors. And the court has interpreted state action very narrowly. So for example, I gave you CLE takers in that reading that's posted online, the case of U.S. versus Morrison, where the court gives its reading that the state's collective inaction in failing to come up with meaningful remedies about gender-based violence, that's not state action. That's of no concern to the 14th Amendment. That's state inaction. So much of no concern that it won't even support a congressional federal remedy to do something about gender-motivated violence. Second limitation, I think Jasmine's comments get at this as well, the 14th Amendment has been construed by the Court for Equal Protection as requiring intent to discriminate. The 14th Amendment Equal Protection Clause goes after intentional discrimination. Even policies that will certainly be known to have a devastating impact with respect to gender or race do not trigger meaningful review without proof of intent. So, for example, in the Feeney versus Massachusetts case, a very strong veterans preference that gave any veteran the automatic job over any non-veteran had the function of excluding women from desirable state jobs. The court's response to that was, well, you have to show that the legislature did it because it kept women out of jobs, not in spite of the fact that it kept women out of jobs. A very high bar, especially because so much bias operates at the unconscious level. Relatedly, the court understands an equal protection violation as being about the different treatment of similarly situated persons. That's what violates equal protection. It's in the realm, though, where women are the least similarly situated, 5 o'clock problem, that you see some of the deepest gender injustices. Pregnancy, domestic violence, rape, caretaking obligations, and all of these areas where women are, because of subordination, not similarly situated to men. Equal protection does very little. The upshot is that what equal protection really goes after is sex-based classifications in law, which are no longer a central locus of gender inequality. Indeed, the very dearth of winning equal protection gender cases contributes to the sense that women have arrived. Whatever lingering inequalities there are must be from women's own choices. Third limit, and then I promise to end the downer part of this. By proceeding by an analogy to race, the court's equal protection jurisprudence treats race and sex as separate and distinct categories, to the detriment of more robust theories of gender justice and racial justice. In the Frontiero case, for example, that I mentioned, where a plurality of 4 justices of the court make an argument for strict scrutiny for gender. They never got the 5th vote, but they made their argument based on an analogy of women, comparing women to African Americans. And when you read that passage, it reads as if all the women are white and all the African Americans are men. And that distorts the court's understanding of gender injustice and racial injustice. For example, when the court criticizes the romantic paternalism of putting women on a pedestal, that proverbial pedestal was never open to women of color whose experiences of gender inequality have differed from those of white women. A conception of equal protection that grants equal treatment only to persons similarly situated to the most favored group will always work better for the most privileged members of a subordinated group. Okay, now to the more uplifting part, maybe, the legacy, the future promise of the 14th Amendment. I would say despite the doctrinal limitations, and there are even more, the promise of equal citizenship that the amendment gives us has helped shift the norms of gender equality beyond the confines of the doctrine. Women's calls for equal rights have been both buoyed by the constitutional successes such as they are, and even more important, they have been fired up by the constitutional losses, which can then become a predicate for statutory grounding of stronger rights for women. For example, when the Supreme Court famously in 1972 in Godoldig versus Iao held, perhaps ridiculously, that discrimination against pregnant persons is not sex discrimination. That's just discrimination separating pregnant people from non-pregnant people. It's not sex discrimination. The Equal Protection Clause is not offended by that. Actual court ruling in 1972. That sparked a reinvigorated women's movement that led to passing the Pregnancy Discrimination Act in 1978 at the statutory level. Congress can't, of course, overturn the court's interpretation of the Constitution, but at the statutory level, granting statutorily enforceable rights for pregnant women and saying, yes, it is, court, sex discrimination. That was a dialogue, really, between Congress responding to a social movement and the court. As new social movements press for gender justice through new forms, Pink Pussy Hats, the March on Washington, #MeToo, women frustrated by limited court rulings find new ways to press claims for equal citizenship, equal protection of the laws, and this momentum may find purchase in federal, state, or legislative reforms, or even lead to cultural change in their own right. Equal protection may do nothing to rein in the private sector in paying women less, but Time's Up might press non-state institutions to make good on those promises of equal citizenship. Of more recent historical lineage than claims for women's equality, we are seeing claims by LGBT persons long excluded from constitutional recognition gain traction, leaning on an analogy to women's equality and asserting equal protection claims. Now, the court has not yet endorsed that analogy nor officially granted heightened review, but it has struck down laws criminalizing same-sex intimacy, penalizing same-sex unions and denying same-sex couples marriage rights, implicitly extending equal protection's promise of full inclusion. So, wrapping up now, where we go from here with a newly comprised Supreme Court remains to be seen. But in the long arc of history, the fate of the 14th Amendment's promise will not be determined by any one court, not even the Supreme Court. The constitutional promise of equality as it relates to gender will continue to be the source of rights claiming by women and other gender-oppressed groups, even when those claims are doctrinally rebuffed. They may yet find footholds in other legal and cultural venues. So, to paraphrase a quote from Justice Kennedy, as the Constitution endures, persons in every generation can invoke its principles in their own search for greater equality.
Good evening. How are you all? I want to thank Associate Dean Brake. She's not only a faculty member, colleague, she is our Associate Dean for Faculty Research and Development, I think. And she's the one who organized this panel. I'm very happy to be part of it. The most important issue, of course, right off the top, since I'm on the third shift here, is to ask, have you had enough coffee? There's plenty of it back there, all right? So we're ready to start. I'd like to take a little different path and to talk to you going back to the Bill of Rights, the first 10 amendments. With the Bill of Rights was the piece that was missing from the Constitution, the pieces that got the Constitution ratified. Here's the thing about the Bill of Rights, those first 10 amendments. They only applied to the federal government. They only restrained the national government, not the states at all. That was the way they were intended, and that's what they did. It wasn't until about the 20th century that you get the Supreme Court beginning to take a hard look at that, and that was looked at through the 14th Amendment's due process clause. The only part of it I will read is that nor shall any state deprive any person of life, liberty, or property without due process of law. I don't know if you know this, but there's almost identical language in the Fifth Amendment. It was already there, but it had nothing to do with the states. It only restrained the federal government. So in the 20th century, the Supreme Court begins to pick out one piece at a time from the Bill of Rights and to ask, is this Bill of Rights guarantee so important, so implicit to our scheme of ordered liberty, that it should be considered included or incorporated into the 14th Amendment due process clause? The 14th Amendment, of course, was all about the states, as you've heard. That was its whole purpose. That was the framework. So do we think that this particular Bill of Rights guarantee was so important to the way that the country works in the sense of fairness particularly, that it should be included within the 14th Amendment due process clause and therefore applied to the states? If that's the case, you have the states now having to follow the pieces of the Bill of Rights too. Now, they didn't do them all at once. There was one theory like that, never carried the day. So this was called selective incorporation through the 14th Amendment. At this point, right now, there aren't many things left in the Bill of Rights that haven't been incorporated. There are a handful, maybe 5 or 6. I'm going to focus on just 2 of the things that the Supreme Court did incorporate over the course of the 20th century, because I think these 2 things, number 1, they come from criminal procedure world where I live. Number 2, they are very important to how our criminal justice system operates. And number 3, they illustrate both the great promise, the way that the 14th Amendment swept in the Bill of Rights guarantees, really made our country different in some very important ways, but at the same time left enormous challenges that we're still having to face now, even with the Supreme Court's actions. So the 2 I'm going to focus on are the 6th Amendment right to counsel and the 4th Amendment and its guarantee against unreasonable searches and seizures. The Sixth Amendment, among the other things it does, is guarantees the assistance of counsel for one's defense, right? As I said in the beginning, only applied to the federal system. And actually, back in the day, all it guaranteed was if you could afford a lawyer, you could bring that lawyer to criminal court with you. That's all. It wasn't until 1914 that the Supreme Court said in a case called Weeks versus the United States that for federal court purposes, federal charges, if you were charged in federal court and you wanted a lawyer but you could not afford one, the federal government had to appoint one for you, but that was just the federal government. The Supreme Court does not face the question about states until much later. Excuse me, I gave you the wrong case. I got a little confused in my notes. It's Johnson versus Zerbst in 1938. That's when they create that right, okay? So it's all the way to 1938 until we get a federal right to counsel for people who are indigent. All right. So the court first takes on the case in the states in 1942 in a case called Betts versus Brady and asks that fundamental rights question. Is the right to counsel such a fundamental right, so fundamental you can't have a fair trial without having a lawyer if you want one and can't afford it? And in 1942, the Supreme Court said, no, it's not. It's not that kind of a right. It's not essential to a fair trial. It took another 2 decades and a little bit more to 1963 for the matter to come up again in the landmark case of Gideon versus Wainwright. And in Gideon versus Wainwright, the court responds to an informa pauperis petition, a petition from a person who can't afford a lawyer, who wants a lawyer, who is up on felony charges in the state of Florida, and the Supreme Court said Betts was wrongly decided. Lawyers, the court said, were, quote, necessities, not luxuries, when one faces charges in criminal court. Whenever a person who had resources goes to criminal court facing charges, when the government goes to criminal court to do its business, there are lawyers there for either. And the same has to be true for people who want lawyers but who don't have the means to afford them. Otherwise, the system is skewed. The Due Process Clause, the court says, requires each state to give indigent people counsel when they cannot afford it. And I'll give you one short quote here. In our adversary system of criminal justice, any person hailed into court who was too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. This seems to us an obvious truth, right? The concept of ordered liberty and due process and fundamental fairness requires it, said the Supreme Court in Gideon. That was for felonies, and then 9 years later, the court decided a subsequent case that included most misdemeanors in most situations. Now, the court left how this was to be done, how it was to be accomplished, to the states. More to say about that in a few minutes. So that's the incorporation of the Sixth Amendment right to counsel. The Fourth Amendment against unreasonable searches and seizures, we haven't had that read yet, so I'll just give you a little sliver of that. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And then a lot of words about how warrants are used. Now, the Supreme Court took this possibility, the possibility of incorporating the Fourth Amendment into the 14th Due Process Clause, took this up in 2 stages as well, but in a kind of a different way than they had with the right to counsel. First, the court looked at the question, again in the 40s. This time the case was called Wolf against Colorado. It was in 1949, and the majority said unquestionably, absolutely without question, the Fourth Amendment is a part of that fabric of ordered liberty. We must have it. It is fundamental, and it is hereby incorporated into the Due Process Clause of the 14th Amendment and applies to the states. However, wait a second here, that part about what we do about it, this stopped them in their tracks. the court said that the remedy for when a police officer were to violate the Fourth Amendment, if that should ever happen, that was a different issue. And they say here, the ways of enforcing such a basic right raise questions of a different order. So what's going to be the remedy? Would the court impose on the states the exclusionary rule, which, and this is the Weeks case from 1914, I talked about it before, this is where the Supreme Court imposed the exclusionary rule on the federal government. The Fourth Amendment had an exclusionary rule for federal cases only from 1914. Would they apply that as well as the Fourth Amendment itself? And the court said no. As far as the remedy, we're going to leave that up to the states. All right, plenty of, there's a few states now that have an exclusionary rule in 1949, but most don't. They rely on tort suits, they rely on internal affairs complaints or public pressure or going to the mayor or whatever it is, and that's fine. Let's just let them sort it out. So you had a situation where the Fourth Amendment guarantees applied, but it was without any remedy. Right, yes, remedy, no. And that was how things were left. So I thought I would give you a little slice of what that world was actually like, that world between Wolf against Colorado and the case that comes in 1961, Mapp versus Ohio. In that period of time, the Fourth Amendment applied to the states, but the exclusionary rule did not. And rather than take it from me, I'd like you to hear from another person. This person's name is Remo Franceschini. Remo Franceschini was a New York Police Department detective starting in the late 50s and then well into the 60s and so forth. He wrote a book called A Matter of Honor, One Cop's Lifelong Pursuit of John Gotti and the Mob, published in 1993. We're not going to talk about John Gotti here at all, okay? But reading this book, there are a number of little things that caught my Fourth Amendment eyes. He talks here first about the well-known practice at that time in New York called giving a guy a toss. What this meant is if you were on the street, driving down the street, walking down the street, you saw a person, you didn't like their looks, you thought they looked suspicious, you just wanted to have a good time, whatever it was, you just throw them up against the wall, put them up against the car, and give them a toss. This is the forerunner of stop and frisk. You just go in their pockets, open their pocketbooks or backpacks or luggage or whatever it is they have, and just search them, just because you want to. This was standard operating procedure. Here's another piece of standard operating procedure. And here I'm quoting him. We used to go into what we called the Valley, down on 8th Avenue in Harlem, and raid the pool rooms. We didn't have search warrants. We just went in the place and started something. Of course, the place would be dirty. We'd line them up, search them, and lock them up for disorderly conduct, some for possession. We'd call the wagon and take 15 people out of there, take the whole crew down. That's the kind of fear and respect we commanded. They knew we controlled the streets, and they knew we controlled that room. Right? Just Fourth Amendment applies, but nobody can do a thing about it. Right? That was the world. Right? And it's no accident, in my humble opinion, that happens in Harlem. Right? If you want to go for a place where the police don't have to follow the rules, go into communities of color pretty much anywhere. Back then, some would say now too. So this all was called to a halt in 1961 with the case I mentioned a minute ago, Mapp versus Ohio. In that case, the Supreme Court finally says, okay, we've thought about it, we see the data, to the extent that they had looked or bothered. These other avenues don't work. The exclusionary rule is now incorporated into the 14th Amendment too, along with the Fourth Amendment, because you can't have a right without a remedy. Here's the money quote from that decision. The court says that the Fourth Amendment without the exclusionary rule was, quote, a form of words valueless and undeserving of mention in a constitution. So you go from that case to Remo Franceschini again, and he says his world has changed. All of a sudden, you couldn't stop a guy on the street and give him a toss. You had to have probable cause. You couldn't bring somebody in because you knew he was dirty. You had to see him being dirty. The exclusionary rule essentially shut down police procedure that had been going on for 100 years. Yeah, and maybe it was about time. Well, those two decisions, Gideon and Mapp, were part of bringing the system into the modern era, applying guarantees of the Bill of Rights and, in one instance, the exclusionary rule to the states. But these two examples do something else. They also illustrate not just a kind of triumphant moment of the court applying human rights to people in the states who might not have enjoyed them before. They also, I think, show very clearly the enormous challenges that remain. One person whose work I read a lot of is Bill Stuntz, who taught for years at Harvard before he died too young. And one of the things he taught all of us was that these rights in a constitution, in the world of criminal procedure, they don't exist in a vacuum. They don't execute themselves automatically. Instead, they exist in an entire system, and all kinds of counter pressures exist that work on them and work back against them. There are political pressures, there are budgetary pressures, there are the pressures of crime rates, there are the pressures of all kinds of different things. And therefore, what we have seen in the years since Gideon and the years since Mapp have been different kinds of struggles, and we're still doing it. Just to give a couple of examples. In the Fourth Amendment area, it was the Supreme Court itself that did the backtracking in a case in 1984 called Leon. And in 1984, in that case, the Supreme Court, they didn't have the votes to repeal the incorporation of the Fourth Amendment or of the exclusionary rule, which is the part they really didn't like. They couldn't get it out of the 14th Amendment, but instead they rebifurcated it. All right? They separated, they cut the right away from the remedy, just as has been true in 1949 in Wolf. And they said, well, from this point on, yes, we still have the exclusionary rule, but it will only apply when the party that wants to have it applied to a new situation, a new set of facts, when they can show us that the benefits of that rule in terms of deterring police misconduct outweigh the enormous costs of suppressing probative evidence. And no surprise, we've now had decades and decades of decision after decision by the Supreme Court in which they say, no, the exclusionary rule doesn't apply to that, doesn't apply to that, doesn't apply to that, and doesn't apply to that. All right, so we're kind of back where we started in 1949. And the right to counsel side, I think probably more of you may be aware of this. As I said, the court didn't say, states, here's how you must do it. And we tend to think of the 60s and 70s like public defender's offices sprouting everywhere, great, great days. Well, in point of fact, it has always been a struggle. The stories seem to add up year upon year upon year of underfunding, of crushing caseloads, of things like that, so that the right exists to have counsel, but you have to actually honestly ask in many places, what is it worth? We now have heads of public defender agencies for states and counties going into federal court and saying to the judge, you should declare our agency constitutionally incompetent. We can't take another single case and actually serve our clients. All right? So this is not an easy thing to say, but we're still in that struggle. You are sitting right now in the only state in the union that gives no money from the state level to indigent defense. We're in a club of one. Okay? So Allegheny County, Philadelphia, you might have a decent indigent defense operation, but you go a couple of counties over and you might not have much. So what I want to say to you, and I hate to be a downer as well, is we have some constitutional progress through the 14th Amendment and selective incorporation. But the struggle continues. Now, don't get downhearted about that, though. All of you people in here who are going to be lawyers, and those who already are, what this means is that you get to be part of this struggle going forward. And I'm here to tell you, my colleagues are here to tell you, there is no greater privilege than standing up for the Constitution every single day. Whether you teach it, whether you litigate it, whether you do it pro bono or for your main dish, it can be your fight too. Thanks.
All right. Okay, so now what we were going to do is open it up for questions or comments. I know we really hit a high note there, but we did have quite a few downer moments here on Constitution Day, which may not have really celebrated the Constitution in the fireworks way that I was suggesting here at the outset. But we want to give you a picture, right, of where we are today. So, does anybody have any questions? Anything? Anybody brave enough to be the first question on deck? No questions?
Yeah, it's a law school. We'll call on you.
Yeah, we'll just start right.
There you go.
Here you go.
I'd like to, I guess, hear anything that any of the panelists would like to say about the Enforcement Acts in the 1870s. So I'm in the English department. I research arguments about race and sexuality in the 14th Amendment, and I've gone down a rabbit hole recently, kind of reading the history of Shelby County, and try to kind of like trace, figure out what of the Enforcement Acts survive in the U.S. Code, et cetera, et cetera. But it's like a history I hadn't seen before, and it's completely wild. I mean, the 7th Cavalry goes into South Carolina and destroys the Klan temporarily as a kind of a viable paramilitary force. There's people who violate the 14th and 15th Amendment, white supremacists, are tried in federal courts in front of predominantly black juries. I mean, this kind of inconceivable today, sort of history, sort of briefly existed, and then the Supreme Court, started to, eviscerate them. And so one of my takeaways from reading about the Enforcement Acts, I guess, is the court itself as a particularly elite institution seems to be a place where inevitably, attempts to enforce the Civil War amendments as they say they should be, kind of completely gets rolled back. So that was actually more than I intended to say. I guess anything about the Enforcement Acts in the 14th Amendment.
Okay, anybody want to take? Debbie, she's ready.
That's a very deep question with a lot of knowledge behind it, I can tell. And so I don't really have a specific answer except to say that I think that the court's early decisions, not just with gender but race also, inauspicious would be putting a nice face on it, right? The civil rights cases, first time the Supreme Court construes the Reconstruction era amendments, and Congress's power to enforce them holds that Congress doesn't have the power under the Reconstruction amendments to prohibit race discrimination in public accommodations, right? We've taken that view of state action that again takes in U.S. versus Morrison all those 100 years later. The decision just gets worse and worse the deeper you get into it, until when the court gets to the 13th Amendment argument, right? It says at some point the newly freed slaves must cease to be a special favorite of the law, So it's just inauspicious, the court's early decisions enforcing the Reconstruction Amendment. So the Reconstruction era history is fascinating. So I would just encourage you to keep going with that project. Look forward to your sending us a copy of whatever it is you write based on that research.
Anybody else want to? I think I'd only mention here that I think a couple of times now we've heard of, at least, in the examples that were provided, some disappointment in the court and its decisions. And should that surprise us over time as a, sort of the kind of body that the court is, are we surprised that we have these up and down moments when you have 9 members of the court who are largely white and male for the vast majority of its existence? Does it surprise us to hear that we still have these moments with the court? And what kind of opportunities do we think there are with respect to the court? I think that's a really tricky question to grapple with. There's lots of people writing on whether we need a different structure. But of course, that's one of the things that you hear throughout what has been said tonight. Other questions that people have? I mean, it's kind of hard to follow that one, I understand. Anybody have any questions? Yeah.
Question, but a comment. I was a federal prosecutor for many years, and I had a case in Alaska where the defendant was perplexed that there would be a Batson challenge by an individual who was white to a prospective juror struck who was African American. And I was perplexed. I never saw that before either in all my career as a federal prosecutor for like 15 years. But I gave a reason, and she thought it was a valid reason, and I didn't seem to have much issue with it. But it was kind of a twist, so to speak, on Batson, where it wasn't an African American defendant objecting to an African American being struck on the jury, but it was a white defendant making a Batson argument. I thought I would just share that because that was the only time in my prosecution history that kind of issue arose. It got resolved fine, but I thought I would share.
Hello, thank you for,
Further going to comment on this.
yeah, I don't know if this is on. I think
Yeah,
this
it is.
It is? Oh, okay. Well, it just makes me want to sing. I get this like American Idol moment. I don't want to do that. That is interesting. It's not that rare, really. There's often this notion that people object to people like this idea of a jury of your peers, that you want folks just like you. But the Sixth Amendment, which is a fundamental right, part of it is to have an impartial jury that's drawn from a fair cross-section of the society. So that's a constitutional right. And the defendant can have basically kind of like a third-party standing to really vindicate not only his or her right to having a jury from a fair cross-section of the community, but also it relates to the juror. I mean, who in the world? You all been summoned for jury service and be, yeah, and then be like, wait a minute, I wasn't selected? You mean I don't have to waste all of my time right here? Oh, I'm gonna fight that. No, right? So it really is there's a need for the criminal defendant, particularly, to be able to vindicate that discrimination. So it does happen. It does happen.
All right, we're at 6:03, so let me see, is there any, there's another question in the back.
I just had a bit of a question about the cross-section of the selection of juries and women's rights. I heard a story once about a woman who was in the selection process, and it was a case involving, I can't remember if it was sexual assault or battery, but it was an issue where there was about 12 women left out of 20 or 30 people, and they asked if any of the women had been assaulted, and about all of them raised their hands, and all were dismissed. And I was just wondering, like, what is the current process, and how likely would it be that in today's day that a jury of my peers wouldn't have at least some men and some women, or some people of color and some people who are white?
Right. That is such a tremendous story, right? To imagine, when we think statistically that a lowball figure is that 1 in 6 women have been either raped or attempted rape, and that's only one very narrow category of sexual assault. So here, when we're looking at sexual assault, really is a subordination of women that then women who were subordinated, right, statistically are then being excluded. So I think that's very complicated. I think we can also think about it as the disproportionate number of people of color, particularly Black Americans, who are excluded from jury service on the basis of having a prior felony conviction. Right, they're disenfranchised in that way when there are systemic and structural reasons for that, not because of the population's increased criminality. So I think that those bring up some really important issues. But that sort of systemic, sort of, I think that there'd be some really unique 14th Amendment arguments there. And for this scenario here where women were excused because of their experience of sexual violence. There also, if that's routine, if it's systemic enough, then there could be perhaps a Sixth Amendment fair cross-section sort of claim, and that's where we need innovative, thoughtful advocates and attorneys, right? This isn't automatic. These rights aren't given, but they're fought for.
David wanted to answer.
Yeah, let me just add a comment about how race might work in the same way. Imagine yourself as a defendant in a federal case here in Pittsburgh. Pittsburgh is the Western District of Pennsylvania. I think it's 26 of our southwestern Pennsylvania counties. Is that right, Chuck? The Western District is at 26 counties. All right, so if you're an African-American defendant here in court in Pittsburgh, in federal court, your chances of having black veneer people who might be in the pool in federal court, just baked into the cake, the demographics are against you, right? So it's going to be very hard to get all that. So that's an example of sometimes you have the right, but the system is very hard to get by.
So it's a great question. I just wanted to note that there is a Supreme Court decision holding that the Batson framework applies to gender, JEB versus TB, decided in the early 1990s. But here's the rub. If the court were convinced that they were using a sexual assault experience as a proxy for getting out women, then it would violate equal protection. But if they thought they were using that and it just happened to affect mostly disproportionately women, but some men too, then they would see it as not gender and so not a violation of equal protection. That goes back to the difficulties it creates to have such a sharp divide between intent and effect, because some things really are so mapping onto the distinct experiences of a group that it just seems kind of ridiculous to think that that's a gender-neutral reason. But I think that is how a court would look at it.
All right, well, with that, I think we better close. Can you join me once again in thanking our panelists? All of you for being here with us on this day. As I will now further call it, it is the Sweaty Sock Day. No, the Sweaty Men in Stockings Day. And remember that the Constitution really does serve as inspiration. Despite the downsides of what we have talked about here today, many of the good things that we come away with and the progress that we've made, the arc may be long, but justice wins out. So thank you again for all being here. We appreciate it, and please enjoy the cookies that we have in the back.